Hi, welcome back to Jus Cogens, the International Law Podcast. This is episode 7, and today we'll be conversing on law and morality at war, and we'll be joined by Professor Adil Haque, who is a professor of law and Judge John O. Newman Scholar at Rutgers Law School. He writes on the law and ethics of armed conflict, international criminal law, and criminal theory. His first book, Law and Morality of War, which was published in 2017, and we'll be discussing chapter 2 from that book, which is titled Law and Morality. It was also selected by Oxford University Press as part of 25 articles in its Promise of the International Law series under the section International Peace and Security. Thank you so much, Professor Adil Haque, for joining us today. It's an absolute pleasure, and we are so glad that you could come on board on the podcast and have a discussion with us.
It's my pleasure. Glad to be here.
I think before we get into the detailed conversation, if you could just give us a brief background into why you chose to write on this particular issue. Why did you feel the need to explore this in so much detail?
So I think that when I entered the legal academy, or the academy in general, it was a very interesting time because the moral philosophy of war had been revitalized, and it was a very rich and robust field. And so since I had an interest in the international law of armed conflict, it just seemed sort of natural that I'd be drawn into the philosophical discussions as well. And so for a few years, I basically wrote separately, an article in a philosophy journal, an article in a law journal, speaking to different audiences, in their own language and on the issues that they were directly concerned with. But after a few years of that, I wanted to bring those two strengths together in a kind of unified view, and try to present ideally to both groups of scholars a view of how legal and moral reasoning about armed conflict might be integrated and mutually reinforcing.
So how would you describe your general approach towards law and morality at war in a nutshell, just based on the entire premise of your book and specifically regarding this chapter? How would you summarize it?
Sure. So I would say that my approach to moral theory falls within kind of a mainstream of non-consequentialist or deontological moral thinking, which tends to emphasize the rights of individuals and their moral responsibilities to one another, as opposed to aggregate welfare or other beneficial consequences that might arise and be important in their own way. And with respect to the law of war, I guess I think this will kind of take us fairly deep into the core argument of the book. I see the law of armed conflict as providing a kind of moral service to those who fight an armed conflict, basically to help them conform to their moral responsibilities more closely than they could on their own. And so I look at the law of armed conflict through a moral lens. Basically, how can it help us minimize the injustice of war?
Professor Haque, you sort of even in your book and even in the chapter, you've categorized the positions on IHL in 4 subsets, essentially, the ones that you've also intimated just now. I think they fall into conventionalist, revisionist, humanitarian, and service, the one that you prescribe to. So probably my first question is, how does that have a practical bearing on the interpretation of the law in terms of the distinctions that you make? I think that's a good way to perhaps get further in and deeper in.
And if I could just add to this question, could you also explain for the viewers as to what these 4 school of thoughts are as well?
Mm-hmm.
So what I call conventionalism is a view that's associated with Michael Walzer, who's a political theorist who wrote a very important book toward the end of the 1970s called Just and Unjust Wars. And it's primarily a book about the morality of war, but for Walzer, law and morality, he has a moral view that I label conventionalism. He thinks that morality is about a set of social conventions that evolves over time as different societies reflect on their fundamental values. and the deeper principles underlying their practices. And so because the law of war is part of our practices of regulating war, law is already part of our moral discourse. That's what I call conventionalism, and it has a very important component to it, which is that for Walzer, both the law of war and the morality of war give combatants an equal right to fight, irrespective of the justice or injustice of their cause, subject to constraints, of course, of distinction, precautions, and proportionality. But each one of them has a kind of moral entitlement to fight, and to fight to win, irrespective of what fighting. Revisionism is a label associated with an alternative view of the morality of war, which emphasizes that the morality of war is fundamentally asymmetrical. In any given armed conflict, only one side can be on the right side and have a right to fight. Unfortunately, in many wars, neither side should be fighting, but at most one side has a right to fight. And yet, revisionists tended to accept the legal premise that the law confers on combatants an equal right to fight, and this sets up a direct conflict between law and morality. The humanitarian view can be separated, but I'll relate it to the revisionist view. So suppose you thought that law and morality the law and morality of war are fundamentally inconsistent because the law provides an equal right to fight and morality does not. Then you might think, well, look, if law can't reflect deeper moral values, what good is it? And the humanitarian view says, well, one thing it can do is at least minimize the suffering and horrors of war to the greatest extent practically possible. So innocent people will still suffer and die, but fewer. Combatants who've done nothing wrong morally because they're fighting for a just cause, they too may be targeted. But again, no more than is necessary for one side to pursue its political goals, which on this view, they're probably going to do anyway. So the best that law can do is eliminate the unnecessary hardship and sufferings of war. And then finally, my own view starts by rejecting the premise that the law of armed conflict confers on both sides an equal right to fight. So in my view, the law of armed conflict is a prohibitive body of law. So it doesn't authorize or entitle anyone to do anything. It just tells people what they can't do. Once that is established, it opens up the possibility of a more constructive relationship between law and morality. And the one I develop is, as you mentioned, this service view, which borrows heavily on Joseph Raz's service conception of legal authority, which is basically the view that when law claims legitimate authority, the only way to, or the primary way, the normal way to justify that claim is to show that law provides a moral service by helping individuals conform to their moral obligations more closely than they could on their own. So just to say a little bit about that, suppose we had the correct, true moral theory, and we could just hand it to soldiers as they go off to war. Is that the best we could do for them? Arguably not, because soldiers would then have to apply that true, correct moral theory under terrible conditions that are not at all conducive to moral deliberation. Limited information, limited time, stress, fear, anger, in-group, out-group bias, motivated reasoning, just a terrible set of circumstances under which to engage in moral deliberation. And so the service view says what law can do is provide a set of rules which, if soldiers follow them, rather than try to get morality right in these very difficult circumstances, they'll actually behave better with respect to their own moral obligations than they would if we just sort of left them to their own devices. So those are sort of the four views that I discuss in this chapter.
Right, so Professor Haque, just as a follow-up then, how does this play into the existing framework of IHL? Because you said that, you know, it's about essentially deriving a set of rules that simplify it and provide a moral service to combatants and belligerents. And so I just wanted to know whether how you think it plays into the existing framework. Do you think there are any changes that are required or reforms, such and such?
Yes. So what is it? Chapter 4 of the book propose a reform, because I think that even though there have been some very interesting arguments to the effect that IHL, as it exists now, prohibits the unnecessary killing of enemy combatants, I don't ultimately find those arguments persuasive. I think this is a gap in the law, and that the law could be improved from a moral point of view if it did prohibit the unnecessary killing of enemy combatants. So that is a moral service that the law could provide to soldiers. It currently does not. It should. So that's an example of the service view proposing a reform to existing law. And with respect to interpretation, most of the book is about existing rules of IHL that are to one extent or another vague, ambiguous, or otherwise indeterminate. And there the argument is that when social sources, positive legal materials, leave the content of law indeterminate, we should interpret the law in the way that would provide the best moral guidance to a theory of how to interpret IHL when text and social practice runs out.
Right. So again, I'm sorry for asking another follow-up, but I find this very interesting. This is something that you mentioned in your chapter as well. You talked about the ICTY judgment where they talked about in situations of doubt, the situation must be viewed in its narrowest possible sense, at least insofar as treatment of the activity is concerned. So and then you follow it up by saying that, oh, but in the service we advocate for creating a balance where you look at, you know, what would best serve the moral obligations of the situation or that the situation demands. So would you not then say that this may lead to a situation where it becomes confusing for everyone, perhaps also adhering to those IHL obligations, and also for military commanders as far as giving orders are concerned, and whether or not that creates a doubt then as to what is. And then you also referenced the I'm sorry, was the factual, the fact belief or fact relative sense, or the belief relative sense. So that's something also I just wanted to sort of encapsulate. Apologies for the long question, but
that's fine. So good. So I do think that so in one part of the book I try to show how this service approach to legal interpretation can actually align with existing approaches. So the one that you referenced just now is one that I think on its own terms is correct. So I think that the purpose of IHL is to protect individuals, civilians, and those out of combat. And then there's sort of an ellipsis, because it's not to it's not to the kind of ultimate logical extent. There's some check there. So what is that check? So sometimes it gets articulated as to the greatest extent practically possible. We can talk about military necessity if you want later on. In more recent work, what I've said is that, you know, really what is filling in the other side of this protective interpretation of IHL is the fact that, in fact, some people do have a right under international law to fight, namely if they're fighting in a war of self-defense into UN Security Council authorization. So if you took a protective interpretation so far that it would actually make it impossible for people to actually defend themselves against aggression or fulfill a Security Council mandate, then this would result in basically a conflict between the jus ad bellum, UN charter system, and the IHL, and that should be avoided. So one way to think about my view is to say, well, look, if we think about why it is, if we want to understand what is morally significant about fighting a war of self-defense or stopping a genocide pursuant to Security Council authorization, why those are important goals that may mean that the most protective interpretation conceivable of an IHL rule is actually not the best one. When we cash that out, you'll end up with something like the service view, where we're actually trying to tell soldiers, look, in these cases where you are both engaged in activity that is harming other people, but also trying to protect people from unjust harm. Both of those considerations have to figure into your interpretation of the law. Okay, so that's a way to sort of relate the service view to maybe a more mainstream understanding of interpretation in international law.
Okay.
So if I could just pick up from here. So Professor Haque, in your opinion, is there a difference between the way you perceive the service view or the theory in general in terms of an international armed conflict and a non-international armed conflict?
So I don't, and I think it's actually a virtue of the view that it can apply across those conflicts, because some of these alternative views I think are really problematic. So if you think in particular about the conventionalist view, so it's simply not the case that international law recognizes an equal right of non-state actors to fight against their own governments or some other government. And when we look kind of doctrinally at this idea of where such an equal right to fight might arise, it doesn't seem like those would apply to non-state actors. So if your whole understanding of what the law of armed conflict is about starts from this idea of an equal right to fight, that then has other implications for the application of human rights law and other things, you're starting with a skewed view. And one way to show that it's a skewed view is to look at the non-international armed conflicts and show that, well, this logic doesn't really apply there, so maybe we should really be looking for something else.
So in one particular passage you mentioned, yet international law hardly gives non-state armed groups a legal right to wage war against their governments. So how would you think this fits in with Article 1.4 of the Additional Protocol 1 in particular to the right of self-determination?
So I don't think that that section is self-addressed to the question of whether certain non-state groups have are subject essentially to the use of balance. So I don't think it really addresses the question whether the prohibition against the use of force applies to them, or whether they have a right of self-defense or anything like that. I think what it can show, though, is that whether a state or a group has a right under international law to fight, let's say, does not yet cannot tell us much about the structure and function of IHL, precisely because IHL is supposed to apply to states and groups that don't have such a right. So even if you thought that a right of self-determination could confer a right to fight on some non-state groups, that still wouldn't tell you that IHL contains within it an equal right to fight on both sides. The asymmetry would still be there. Right? And so that alone would show that the conventionalist view has to be wrong.
So one question which I had was in regards to sort of progressing IHL to a place where it better serves the service view. So in theory, to that end, a state would sort of progressively interpret it in a way that sort of gives morality and that sort of fits in morality into the law. But how do you see it happening in the sense that in a combat situation, and this question might have been asked in a different way before, but how do you see in a combat situation that that particular combatant would know as to the specificities of those interpretations and apply it to the situation at hand?
So I think this is where, so the short answer is that they don't, or they can't. And this is why rules of engagement and implementing rules are so important. So the book is a little odd because it's a lot of philosophy, but then a lot of the chapters have these model rules of engagement that actually suggest, here are some, fairly clear, simple instructions that you could give to soldiers, and they would probably be able to understand reasonably well. And they pretty much approximate the law as it is, or as I argue it should be understood. And that's an incredibly important component of this. So the interpretation of international law is going to be done by lawyers. right? Not by 18 or 21-year-old soldiers in the field. So for them, we need an additional step, right, to then distill down the best interpretation of the law to clear, simple rules that they can apply under stress.
And then would you say that that creates room for relativity in interpretation?
Yes and no. So the idea with rules of engagement is that for them to be valid, they either have to map onto the law, but maybe just in more accessible terms, or they have to be more restrictive than the law. One way to think about it is that when states craft rules of engagement, what they're actually doing is discharging their legal responsibility to ensure respect for IHL. You can't ensure respect for IHL by giving rules of engagement that will actually lead to, or let soldiers think, the acts are permitted when they're not. Right? But you can do the opposite. Right? You can have rules of engagement that are more restrictive than the law. Right? And that will be, a discharge of your responsibilities, and it'll ensure legal outcomes, if you will.
Right, makes sense.
Do you think that through the service approach, would that influence the interpretation of traditional principles such as proportionality, military necessity, from the established ways of looking at them?
So I do. So the particular examples you gave, I would treat a bit differently. So proportionality, there's a chapter in the book about proportionality, and I think that we do need to understand proportionality in a pretty fundamentally different way, because the kind of mainstream view is that the proportionality rule asks us to compare incomparables: human life and well-being and military advantage. One is an intrinsic value, and the other is at most an instrumental value. And as revisionist philosophers have pointed out, if you're fighting for an unjust cause, then your military advantage is instrumental to something that is of moral disvalue. It's actually bad for you to progress toward victory because you're fighting for an unjust cause. So either you're left comparing apples and oranges, or you're attributing moral value to military advantages that don't actually have moral value. If they're just contributing to the side that may be fighting for an unjust cause. So I think we need to rethink proportionality. I think that we need to understand the value of a military advantage, which could be eliminating an enemy soldier or unit, or destroying a weapons depot or whatever. What is the value of that military advantage? The value of that military advantage is that without it, the other side will kill and maim and destroy less than they otherwise would. So now you're attaching a moral value to military advantage, but that does not refer to the overall justice of your cause. Right? And as a result, it's a moral value that you can advert to and consider and weigh against the harm you're likely to inflict, even if you're not totally sure you're fighting for the right side. Maybe you think you are, but you're worried your government might not be telling the truth, etc. Right? But that's an understanding of proportionality that answers both of these two objections. Because you're weighing intrinsic values, lives and lives, it steps the incomparability problem. But because you're looking only at the lives saved by this action, not the overall cause, it sidesteps the asymmetry problem. So in short, yes, this is a very different understanding of proportionality than you get in mainstream IHL. And it is very much aimed at bringing the service view to bear.
Right. I bring that up because in this chapter, you bring up a hypothetical example of an attack on two bridges, which is equally proportionate, and it renders the same military advantage. But targeting one bridge would result more civilian losses and the other would not. And you argue that one would result in unnecessary killing of those civilians. But under the law of armed conflict, you argue that both are still proportionate, but one would be more arbitrary than the other. And there you talk about the interplay of between IHL and IHRL, that even though it might not violate IHL, but it still might be arbitrary. Can you please talk a little bit about that, and also maybe how do you understand the interplay between IHL and IHL?
Absolutely. So this discussion is in a section about human rights law, the relationship between IHL and human rights law. And basically, it's resisting the view that killings that conform to IHL are not arbitrary under human rights law. So that's the view I'm rejecting. So how do I go about showing that? One way I go about showing that is to emphasize the contingency of the content of IHL. That IHL contains rules that it might not have contained. And yet, if we think these rules, and yet the existence of these rules would be absolutely critical to minimizing arbitrary killing in war. So the example you're referring to is sometimes called the target selection rule, and it's basically the case that you gave. There are two targets, so there's the classic example is that there's a railroad and you can destroy an isolated piece of track where there's no one in harm's way, or you can bomb the train station where there are civilians and others. Military advantage is the same. You cut off the supply line either way. In one case, you kill a lot of civilians, but cutting off the supply line is so important. The argument is, well, it's proportionate, right? The military advantage does outweigh the harm to civilians. Everyone can immediately see that would be an arbitrary deprivation of life. You would be killing those people for no reason at all, right? Now, as it turns out, IHL has a specific rule saying, no, if you're in that situation, you have to bomb the isolated piece of track. You cannot bomb the train station. But what if it didn't? And in fact, at the time I wrote the book, one state said it didn't. Right, so the U.S. Department of Defense had released the first edition of its Law of War manual, in which it rejected the target selection rule. So
Right.
No, you can bomb whichever target you
So
want. They changed that view, but it shows that in principle, IHL might fall terribly short of prohibiting arbitrary killing in war. And all of this is to show that the concept of arbitrary killing under human rights law has to have its own content. It can't just rely on IHL to prevent arbitrary killing in war, because IHL might fail in that task. And then you'll want human rights law to have its own content and offer its own protections.
So Dr. Haque, I had a very that's a very interesting insight, and I'd probably have a follow-up about that. Would you not say that within IHL it is inherent to the framework itself to essentially put prescriptions on superfluous injury or unnecessary suffering? So in this situation, then it perhaps is the case that a state or a number of states have, to the detriment of their own understanding of IHL, perhaps advocated for something that is, I think, inherently not part of IHL. So then would you still say that there's this conflict where there's this lacuna or gap within IHL, something that maybe you can provide insight on?
Sure. So first, this specific example is the U.S. Department of Defense or at length in blog posts and articles, and so you do not need to convince me that it is not a plausible view of the law, and it's a very, very good thing that they changed it. So I'm completely on with that. So look, yes, I think that there are many interpretive principles within IHL itself that we can appeal to resolve controversies over the content of IHL. Absolutely agree with that. Here's another example. So most of the major human rights treaties were adopted at a time when the law of internal armed conflict, non-international armed conflict, civil war, was extremely underdeveloped.
Right.
Even at the time Protocol 2 was adopted, the United States said there's just no customary law regulating the conduct of hostilities in internal armed conflict. So think about what it would mean at that time to say, if a killing conforms to IHL, it is not arbitrary under human rights law. You would be saying that a state can kill in an internal armed conflict without taking any precautions, without abiding by the proportionality rule. using human shields, right? And it would not violate human rights. Those would not be arbitrary killings.
Right. So then your position is that there's a danger, essentially. It's like a slippery slope argument where there may be a danger that a state might interpret, at least at that stage, to say, oh, if there's this... So
it's not that. It's not that. It's to show that. So what some scholars, based on a passage from the ICJ's Nuclear Weapons Advisory Opinion, have tried to argue, is that there's some kind of just principle of logic that if a killing in war conforms to IHL, it just can't be arbitrary under human rights law. There just has to be, human rights law just has to meet IHL where it is. And my point is to show, no, it should not. Because if you trace IHL over the decades, if you start in the 1940s, when the new IHL of the Geneva Conventions and human rights law are both taking off, and you trace it through the 70s, through Additional Protocol 1 and Additional Protocol 2, you would see that it would be completely implausible to say that arbitrary killing in war just follows IHL wherever it goes. Think about it, Protocol 1 and Protocol 2 are adopted at the same time. The rules governing the conduct of hostilities in Protocol 1 are so much more detailed, sophisticated, and protective than in Protocol 2. But it's just completely implausible to think that people's human rights are less robust in internal armed conflict than they are in international armed conflict. If not taking precautions would be arbitrary in international armed conflict, because it's prohibited by Protocol 1, it has to be arbitrary in internal armed conflict. Right? Human rights don't change depending on conflict classification. Right? So all these arguments are just meant to break this sort of false equivalency or false correspondence between IHL and human rights law, to really emphasize these are two bodies of law. They relate to each other in all sorts of important ways, but it is simply not the case that the content of the human right to life just follows IHL along its trajectory and path of development.
Professor Haque, just from a practical point of view, I was just wondering that some might say that during an armed conflict, for a military commander who has to make a decision, entertaining two different sets of definitions regarding what arbitrariness is, wouldn't that make his job or her job even more difficult? That he has to decide whether this is arbitrary under two separate regimes of law.
So first answer is one that we've talked about it a bit already, which is that that's not the job of commanders, it's the job of government lawyers. It's the job of government lawyers to tell commanders, here are the different legal regimes that apply to what we're doing. And here is the bottom line. Here's what you actually have to do to satisfy IHL, human rights law, domestic law, right? You don't have to do that legal work yourself. We'll do it for you, and we'll tell you this is what you need to do. If you do these things, you will conform to all the applicable laws that are at issue in your operation.
Right.
So reversing back, I have a sort of a more abstract question than the specificities in which we've gone into. So you've mentioned that both sides would sort of have this subjective view that the reasons for going to war, both of them are just. So could we then say that the moral compass, or rather the moral guidance that one draws from like oneself, would change, and because of that it's not very easy for the law to sort of set the parameters in a form of a consensus whereby everyone's moral compass would be satisfied?
So I don't think so, for a couple of reasons. So first, I do think that it is possible to understand the moral rules applicable to the conduct of armed conflict, even if you're still not totally sure about the moral rules governing the resort to force. So I think it is possible to break those two off, do some productive work on the in bello issues, and kind of bracketing the ad bellum ones. Another thing is that this situation where both sides think they're fighting for the right cause can arise for a variety of different reasons, not just moral disagreement. It's often factual disagreement.
Mm-hmm.
The US government tells our armed forces there are weapons of mass destruction in Iraq, we must go in and get them, or there will be a mushroom cloud over New York City. That's not really a moral problem. It's not like US soldiers had necessarily bad moral views. They're just being told something that was false. Right? So often when two sides are at odds, it's not because they have fundamental moral, or they might have different views about the possibilities of reconciliation, of avoiding war and resolving their disputes through peaceful means. So such moral disagreements certainly arise and exist, but I think one virtue of IHL is that we can, to some extent at least, bracket them when it comes to the conduct of hostilities.
So basically my question centered specifically in terms of jus in bello, in terms of the moral direction that one person would have. Does it necessarily mean that the other person also thinks that morally this thing is right? And to then make up a body of law which sort of encompasses everyone's moral sense. Like, is that a possibility? Because there could be disagreements in what we deem morally right in an armed conflict.
If I could just add to that real quick, Dr. Haque, you already talked about like rules of engagement and how that establishes a parameter under which you can and cannot act. But I imagine, and that probably is the case, that it's not as well defined where there are non-state actors and essentially on groups. So in that sense, then there's also this perhaps lack of concreteness essentially in rules of engagement when it comes to organized armed groups, not essentially not a high contracting party. So how do you then see this translating in that as well?
So I think this question about disseminating IHL and developing rules of engagement for non-state armed groups is a very important one, and there are groups like Geneva Call and to a lesser extent the ICRC who are actually trying to work constructively with non-state armed groups to improve their compliance with IHL. And a component of that might be helping them develop rules of engagement that provide those clear, simple instructions that their fighters on the ground could actually understand and comply with under pressure. So I see that more as a practical problem about dissemination and implementation, rather than a more theoretical problem, which I think we have enough of those.
Mm-hmm. So Dr. Haque, you essentially say in your book and also in the chapter that we essentially referenced that the law governing hostilities is defined not by permissions but by prescriptions, and you essentially said as much earlier on as well. So could you just explain a little bit about that as well? Because you clearly mentioned that you bring in the military manual or the Libra Code, and you talk about the word permit, and you also talk about weak permissions and strong permissions, referencing the Lotus Principle. So maybe you could just expand a little bit on that for the audience and for us as well.
Sure. So the basic. So why might one think that the law of war and the morality of war are in conflict? You might think that the law of war confers on combatants on both sides of the conflict a right to fight. And by right, you might mean an entitlement, a justification. It doesn't mean that other bodies of law might prohibit it, and it doesn't mean that IHL is essentially making the moral claim that this is something you can permissibly do. Right? It's not doing any of that. So part of this is, there are basically two sections of the chapter that provide the kind of negative arguments. So one section about the right to participate in hostilities in Additional Protocol 1, and it's to try to show that that right is just an immunity from subsequent prosecution for acts that conform with IHL. It's not a claim right or a liberty right or anything like that. It's just an immunity from prosecution. And that's very important because when you confer an immunity, you're not saying that the underlying conduct is okay. You're just saying there are other reasons not to prosecute you for them. Right? Maybe prosecuting you would make things even worse. It's a different type of claim. And then the other section is about military necessity. And basically what I try to show, and I do this a bit more in subsequent work, is that if you really look at the sources of the idea of military necessity, what you find is that military necessity is actually contrasted with the law of war. It's not part of the law of war. The law of war is still just providing these prohibitions, these constraints, these things you can't do. And this thing called military necessity was supposed to kind of fill up that gap. And so military necessity is what permits you to do what the law of war does not prohibit.
Mm-hmm.
So what was military necessity? It was an unfortunate mistake, I think. So basically, if you look at sort of the late 18th century, you have scholars who say, look, from a moral point of view, if a state had a moral right to fight in self-defense or for some other just cause, it would therefore have a right to do that which was strictly necessary to achieve that just cause. So that was the concept of moralness. There was the idea that when we go to positive law, what we should ask is, well, if the state was fighting for a just cause, would these types of actions be necessary for them to achieve them? And if so, we make those actions not prohibited for either side. And we simply reserve judgment on on which side is in the right and which side is in the wrong. So that moral conception of necessity is no longer it never gets transferred over to the law.
Right?
But what happens in the 19th century with the Lieber Code and elsewhere is that this sort of kind of motley idea of military necessity gets invented in a context where states had a right to go to war at will, right? There was no prohibition on the use of, on the resort to war. There was no just side and unjust side. The idea was that both sides had the war. So if you have this concept of necessity in a legal context where there's an unfettered right to go to war, what you end up with is a completely amoral conception of necessity that has really no normative valence whatsoever. It's just saying that, you know, every state can go to war at will for whatever reason or no reason at all. And in that sense, it can do whatever it needs to do to win. Well, that idea cannot survive the UN Charter. It can't survive the Kellogg-Briand Pact.
Mm-hmm.
The only kind of necessity that can have any legal weight today is necessity in the service of self-defense or force pursuant to a Security Council authorization or something like that. But there can be no symmetrical conception of military necessity that both sides can appeal to. Yeah. That's just not possible anymore because at least one side is fighting in violation of international law. So the necessity of them to win does not exist because they shouldn't win. They shouldn't even be fighting.
Right. So
that's the argument that military necessity cannot be a source of authorization or entitlement under international law anymore.
All right, fair enough. Thank you.
I think that's about it, I guess. Shayan, do you have anything to add?
Nothing as such, but like I was thinking if you could finally give some concluding thoughts on the whole theory to sort of end this podcast.
Yeah, that'd be nice.
Oh, sure. So I guess the main thing that I would tell listeners is that I've been very fortunate that my book has attracted many critics. So if you're interested in the themes of my book, obviously read the book first, right? But then, you know, there's been some really wonderful, thoughtful responses to it. Ilya Lieblich in the European Journal of International Law has a wonderful essay called The Facilitative Function of Jus in Bello. So taking issue to some extent with the idea that IHL is purely prohibitive. Yanina Dill has a wonderful chapter that's available for free through Cambridge called Toward a Moral Division of Labor Between IHL and Human Rights that engages with a number of themes of the chapter and the book as a whole. I strongly recommend it to everyone. And for the more philosophically inclined, the Philosophy Journal Ethics published a symposium on the book last summer with many wonderful contributions. And so probably the thing that I am happiest about with the book is that it has sparked so much discussion and debate and reflection. And my hope is that even if I didn't get it exactly right, one of the folks responding to it and reacting to it will at least get a little bit closer to the truth.
Well, perfect. Thank you so much, Professor Haque. I think I speak on behalf of everybody when I say this was probably the most insightful and interesting discussion that we have had in a while. It was an absolute pleasure to have you on the podcast, and I hope you come again sometime.
Thank you very much, everyone. Enjoy your day.
Thank you.
Thank you. We really appreciate you taking the time as well.
Yeah, thank you so much.
Yes, so that's it from our end, and see you in the next episode.